This is Michael Popok, and it's time for Legal AF After Dark. Why do I have to know about the most intimate details of Fony Willis's life and financial practices? Why? How is that proving that she has an actual conflict of interest to remove her from the Donald Trump prosecution because she occasionally went out and split expenses, apparently, with somebody that she works with? Who cares? And why is the judge giving so much oxygen to this argument when it should have been stamped and snuffed out a long time ago? You want to know more? We break it down on our most recent episode of Legal AF. Here's a clip.
The clip of Donald Trump's lawyer, Steve Sadow, talking about, and Fony Willis didn't disclose her relationship to nobody with Nathan Wade. And she didn't even tell daddy. She didn't tell daddy. I mean, let's be very clear and not mince words. If Fulton County District Attorney Fony Willis was not a Black female prosecutor who was doing an incredible job, this would never be happening, period. Could you imagine them doing this to another type of prosecutor and focusing on their relationships? And I mean, the absurdity of it, she's supposed to tell her father when privately she's involved in a private consensual sexual relationship. She's supposed to go and ask her father or tell her dad, hey, do you know who I just had sex with today? And why are we even talking about who Fulton County District Attorney Fony Willis is having sex with, or when she first had sex with Nathan Wade? What this was supposed to be about was, is there a conflict of interest that rises to the level of materiality that taints the ability of the prosecution to, in a good faith manner, prosecute the criminal defendants, in this case, Donald Trump and his co-defendants? This is not supposed to put a prosecutor on trial for her intimate sexual relations. And in my view, this should have started with a proffer and a very carefully framed line of questioning into the area of actual conflict relating to this specific case. And the moment a witness, whether it was Terrence Bradley or somebody else, did not have personal knowledge about when a relationship started, then they are not to speak on that. As I've said on the hot takes, courts are not supposed to be the courts of gossip. It's not supposed to be the court of innuendo, the court of rumor. People text messages and say a lot of things about powerful people. That does not make it admissible evidence. And so when a witness says, I don't have knowledge, personal firsthand knowledge of when a fact took place, there's nothing else for them to talk about. We don't need to hear people speculating for 15 minutes about the potential sexual habits or private sex of prosecutors and their special counsels. And the only evidence that we had was that two consenting adults at some point in time had a loving relationship that didn't evolve into anything more than that. There was a few trips that they took together. Perhaps it was an HR issue at worst. I'm not even sure it's an HR issue, but people fell in love for a short period of time. And that's it. And so to watch this attack on her, where they put a Black female prosecutor on trial, and to see Ashley Merchant up there, the lawyer for one of the co-defendants, Michael Roman, with her whole shtick and routine, and to watch Trump's lawyer say, oh, you didn't tell daddy? You didn't tell your daddy? I was watching that, and as a lawyer, that made me sick to my stomach to watch that. Judge Scott MacAfee I don't really even care how he rules. Of course, if he follows the law, he should rule that there's no conflict of interest, and that seems to be where he's leaning based on the questions. But the fact that he let his courtroom be used like a circus like that frankly shows that, he clearly did not have the experience for this job. It's not a political thing at all. It's just, what the heck was that? I mean, pathetic. Popok, what are your thoughts?
Let me start with the attacks on Fony Willis. I agree with you. I've said out loud that he got the approach to the hearing ass backwards. He got it exactly wrong. A more seasoned jurist would have done the legal issues first and have them made, as you said, and I've said before, the proffer. What do you got? What's your argument? What's your case law that allows it? Even if I take your proffer, which is the lawyer argument about what he believes or she believes the evidence will show, what is your proffer? Who are your witnesses? What are they going to say? And then if I were the judge, and then I would put their feet to the fire to continue our theme here today and say, okay, well, tell me where under the case law that either presents an actual conflict. And this whole issue that you can see the judge struggling with, and I'm going to talk about the prior disqualification of Fony Willis in a minute, about whether the appearance of impropriety standard is the right one or the actual conflict standard is the right one. He seems to be on the horns of a dilemma and the fork in the road about which one he's going to go down. Even when the lawyer for Fony Willis, and side note, I see why now. I think Karen Freeman-Agnifilo put it well in a pregame chat with us. I see why now Fony Willis, other than Fony Willis herself, hires outside legal experts to serve on her team. I was not blown away by the workmanlike, and that's the highest compliment I can give, the workmanlike presentation of the lawyers for the Fulton County DA defending Fony Willis. They did okay. I'll just leave it at that. I've seen better, but hopefully that is not what's going to rule the day. The issue is whether we're under actual conflict of interest, of which there is not one. The fact that she dated, you said love. It doesn't have to be love. The fact that she dated or had a relationship or had some sort of interaction outside of work with a person in her office on the same side of the V. I mean, this would be different if she had some sort of strange relationship or inappropriate relationship with the victim in a case that she was prosecuting, or something else that could challenge her ethics or something else. But the fact that she, like most people, I met my wife at work. The fact that she had some sort of relationship, and that after he got the job, he used whatever money he had, both from this job and other jobs, and she used cash, and they went and did. They split the cost on some cheapo cruises off of Miami and a DoubleTree Inn visit to Napa Valley. Who cares? You're exactly right. And the optics, the look of a bunch of white lawyers, I'm just going to say it for what it is, a bunch of white lawyers going after Fony Willis as a black female prosecutor, and a lot of white male lawyers doing it. And the way they did it, you think, and this is rhetorical, you think that Steve Sadow, the lawyer for Donald Trump, would start talking about somebody's daddy when they're in their 40s about their relationship? We're not talking about an underage girl. We're talking about an elected Fulton County prosecutor, the madam prosecutor in the case. I mean, the fact that her father even had to testify, McAfee should have put an end to that. But having not put an end to that, for this guy to stand up and talk about somebody's daddy is racist, it's sexist, and it's demeaning. And all they're trying to do is make her inferior, right? Which has those other racial undertones and overtones in their presentation. Now, this is the case law problem. You've got the whole body of law in Georgia that talks about there's only two ways to get a prosecutor off, but there's an exception to that, or there's a common law other way, potentially. The two ways are forensic misconduct, which is a term of art in Georgia, which doesn't exist here. No one's alleging that there's misconduct by the prosecutor in prosecuting the case, hiding evidence, not revealing evidence, and the like, that they should be removed. So take that off the board. Actual conflict is what it sort of sounds like. There is something about the prosecution that is benefiting the prosecutor in a way that an independent prosecutor should not be benefited, right? There's a conflict of interest that so undermines her professional judgment, or what we say, people's confidence in the criminal justice system, that they should be removed for that actual conflict. And based on the evidence that was presented, including Terrence Bradley, who the judge word as not being helpful to his fact-finding at all on the issue. Because the judge put it best when he said to the lawyers, when they said, oh, he was obviously lying in court, Your Honor, based on the text messages. He's lying, and you should take an adverse inference that he's lying to cover this whole thing up. And the judge said, how do you know he wasn't lying in the text messages? How do you know he wasn't lying in the text messages about knowing when the relationship started, and he told the truth in the courtroom? In other words, I'm taking him off the board as a fact witness that I'm going to rely upon. And they put no other witness up, not Daddy, not anybody else, that establishes that Fony Willis lied to the court about when that relationship, whatever it was, started. She said it couldn't possibly be a conflict of interest or that I'm benefiting in any way because I had already gone through and cycled through other choices for the special prosecutor's position before I got to Nathan Wade, and that was after the indictment, not before. Aha, she lied. Maybe she lied about that. Let's get Daddy. Let's get her former law partner for Nathan Wade up there, who completely self-immolated, self-destructed before our very eyes. But my problem is the law. And the reason I said that is because when then Chief Judge McBurney disqualified Fony Willis. Some people might be coming late to the game here and thinking, wow, she was disqualified before. Yes, in this case. And that one, this is before the actual grand jury, special purpose grand jury made its recommendation to indict Donald Trump and others. And then the grand jury actually did indict them. And she was in the investigative stage. But one of the targets of the investigation was Burt Jones, who was at the time an elected official and a fake elector. And her office was investigating and prosecuting him. Unfortunately, Fony Willis, for whatever reason, held a fundraiser or participated in a fundraiser for Burt Jones's opponent, Democratic opponent. And Burt Jones is like, I can't get a fair shake here with this prosecutor. She's supporting my opponent. And they had a whole hearing in front of Judge McBurney. And Judge McBurney did the judicial version of a head slap. He said, what were you thinking, Fony? Miss Willis, what were you thinking? And what he wrote, and this is what I'm worried about, that McAfee, who's a brand new judge, probably looks up to McBurney, who used to be, I think he's either Harvard or Yale trained, and was the chief judge. He wrote in his decision related to Fony Willis that he had to take her off the case and assign it to a new prosecutor, have it reassigned to a new prosecutor for Burt Jones, because this is a quote, the prosecution cannot be burdened by legitimate doubts about the district attorney's motives. Now, he didn't use the term appearance of impropriety, but it came close. And then even when McAfee was questioning the lawyer representing the Fulton County DA, basically trying to keep Fony on the case, and said, well, I understand your actual conflict of interest cases, but in those cases, did they also mention appearance of impropriety? In other words, if a reasonable person would believe that the justice system is being undermined and that she has a conflict and she can't be a fair prosecutor, that's enough to take her off the case. Now, I don't think it's enough, but the fact that he's even struggling with that and then has this language in McBurney's own decision about Fony Willis gives me a little bit of agita about where he's going to go with this. Now, I'll just leave it on this. Even in McBurney's own commentary that McAfee may rely on, he says there has to be legitimate doubts about the DA's motives. And I don't see that here. I mean, there is a case in Georgia in which a prosecutor was basically working on commission. They were getting paid only if they got the conviction. And the court said, look, you got a conflict of interest and an appearance of impropriety, because it would appear to the average public that you may be willing to put your personal gain of making money on the case ahead of your professional duties to only prosecute under the right circumstances. So we're going to take you out of it. You're burdened with that. We're going to relieve you of that burden. And that's exactly where I don't want McAfee to go. Having now flipped the script on how he was going to handle the hearing, now allowing all of this salacious stuff and now he's got it. He's got to figure out what to do with it. All this evidence out there about it. And if he makes that, and he's going to take 2 weeks apparently while the case sort of sits around, hasn't been scheduled for trial. They're getting all their benefit there. And just one last thing on the presentation. Ashley Merchant focused on she's benefiting because she's going out on dates that are being somehow paid for with money that she gave to Nathan Wade. which is ridiculous, and the whole sequence doesn't work for her. Steve Sadow's was different. Steve Sadow's and Donald Trump's is, we don't like the speech that she gave Martin Luther King Jr. weekend at the historic Black church in Georgia, in which she got up for 40 minutes and used a rhetorical device of saying, "Oh Lord, why do these people," and then, without naming names, defended Nathan Wade, defended herself, defended her decision making. And Steve Sadow was like, "Hey, I'm trying to pick a jury one day in a predominantly Black community, and she just went to a predominantly Black church and just called my guy or whatever. He can't get a fair trial here. Appearance of impropriety, take her off." So there's a lot of this, smoke that's buzzing around McAfee, and the question is he? And it's rhetorical again. Is he sophisticated enough and experienced enough? The answer is no, to sort through this the way you and I want him to and come out the other side saying no conflict of interest? Or does he do the easy, cowardly thing and just say, she's out, turn it over to the prosecutor's counsel, let them pick a new prosecutor's office and pick up the indictment?
Well, and that effectively will end the case, in my view, because I don't think it's as easy as finding another prosecutor's office currently in this environment that's going to simply take over the baton right now. And I could be wrong about that. It doesn't necessarily mean that the outcome would be what I just suggested, but I think it'll be hard to find another prosecutor's office, even if it was assigned to it. And I think ultimately, if you apply the legal standard, as I said, courts of law are not courts of rumor, innuendo, and gossip. There is no facts or data that goes to the fundamental issue of the conflict. To the extent there's an appearance of just that this is tainted now and it's gross, is simply because the drama and innuendo and rumor, all of that is the behavior, the gross behaviors, the behavior of Trump and the co-defendants' lawyers, making this implication and innuendo and rumor. And now this whole thing is like, what are we even talking about? So it's kind of self-fulfilled versus was there underlying conflicts to begin with? And to me, that's where McAfee really mishandled this, but we'll ultimately see what he does. And, my view always from the outset was, if you show me that Fulton County District Attorney Fony Willis committed perjury, if there's data and admissible evidence that shows that, I think that not only should she have to be removed from the case, there should be serious implications, to her bar license. If that's what she did, that's simply not what the evidence showed. And I'm focused on the evidence and the data. So that's where I stand on that.
Okay. Lawyers talking about things they know what they're talking about at the intersection of law and politics. How novel. And if you like it, we call it Legal AF. And yes, that cheeky title means exactly what you think. We do it every Wednesday and Saturdays at 8 p.m. on the MeidasTouch Network. If you're already there with us, we thank you for being part of our audience from the bottom of our pod. Take that clip, send it off to friends and family, and ask them to join our experience as part of their journey. And if you have no idea what I'm talking about, this is all content new to you. Welcome to Legal AF. I'm Michael Popok. That was a clip, and we curate the show that we think you need to know every week on Wednesdays and Saturdays at 8 p.m. Eastern Time. And then on Hot Takes, updated clips, the leaders of Legal AF do about every hour right here on this MeidasTouch network. Help them get to 3 million. What a number. Free subscribers, no outside investors. We are the network you've been looking for because we're you. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.